What happens when a defendant walks into court facing multiple felony charges, already carrying a criminal history, and the judge has to decide whether he deserves prison or one last chance? In this courtroom moment, one man is sentenced to years behind bars, while another stands just inches away from losing his freedom forever. But the judge's final warning at the end changes everything. Stay until the end, because what happens next could decide his entire future.
Nine six would have written once. I mean, 1-6.
1916. Okay. Good morning. Are you Patrick Trahan? And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trahan is currently competent to stand trial. Any other evidence with regard to competency
I got it.
from the state?
No.
Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
Here we go.
And are we going on count one only? On the assault on a peace officer?
Yes, ma'am. We may need to go on both on the stage.
Okay. Hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then takes a minute for me to get it. And cause number 26, DCCR 0592. You're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Also, in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true? In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here. All right, so I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And cause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. And I will sign that dismissal now in cause number 25, DCCR 1916. All right. You can go back with the bailiff. Good morning, sir. Are you Eric Tran? And Mr. Parker, will your client waive the formal reading of the motion?
Here we are.
Mr. Tran, in cause number 22-40541, I have a motion to revoke your community supervision. It shows that you were placed on probation January 17th of 2023 for evading arrest or detention with the use of a vehicle, a 3rd-degree felony. And that was a 10-year term in prison that was probated for 5 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of reckless driving November 28th of 2025 in Jefferson County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 10th of 2025 that tested positive for the byproducts of cocaine. And is that true or not true?
True.
And then count 3 alleges that you have failed to provide verification and performing the community service hours as required. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation, but order that you enter and successfully complete the safety program. And then you would be back on probation and required to follow all of the rules and conditions. Is that your understanding?
Judge, that was the recommendation when I spoke with this officer, Joji.
Okay, thank you, Ms. Malfino. And it looks like also you would enter a plea on that reckless driving for the time that you've already
I
served.
think you can get credit. We're probably going to dismiss it, Judge. I mean, it's,
He's got so much
Oh,
credit
okay.
that it
How-
makes it technically easier.
Yes, we're gonna resolve that
Yes,
today.
let him go.
Okay, so then what I'm gonna do, Mr. Tran, it sounds like everybody's wants to get you back on track, and that's what safety is for, so that you can have the tools necessary to be able to stay clean and do everything you're supposed to on probation. And so I'm going to follow the recommendation from probation and the district attorney's office. Find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke the probation, but I'm not going to. I am going to continue you on probation. I'm going to order that as a condition of that probation, you enter and successfully complete the safety program, and then follow all of the other rules and conditions of probation. If you do all of that, we should never see each other here again, and you'll be able to finish that probation or your time while you're out on probation. But you need to keep in mind, if you mess up again, You're going to be back here in court, and we're not going to be talking about the same type of thing. You'll end up going to prison. You've already agreed to a 10-year sentence. Okay. Good luck to you, sir. You can go back with the bailiff.
One wrong decision put these men back in front of the judge, but the next decision could change the rest of their lives forever. If you enjoy real courtroom moments, powerful judge reactions, and shocking legal cases that make you think twice, make sure to *** subscribe now *** and turn on notifications, because the next case might be even crazier than this one.